Welcome to Greenwood's Legal's Employment Law Nowcast, Episode 7. Today we're continuing to talk about the death of hybrid working. Enjoy the podcast. Hello and welcome to our next episode of the Employment Law Nowcast, following on from our previous episode where we debated the death of hybrid working. We're now going to talk about some of the issues that we've identified if employers do decide to take the plunge and either try and get employees back to the office or increase the amount of time that they're in the office. I'm joined again by John Macaulay and Keith Williams. And I'm kicking off this one with kind of one of the more obvious routes that an employee might take if they are faced with a requirement from their employer to increase their time in the office and they don't want to. And one of the more obvious things I'm sure we're all aware of is that they can put in a flexible working request. Currently, it's employees with 26 weeks service or more that can do that. This is scheduled to change. The government have indicated that this will become a day one right. We haven't seen the actual legislation about that specific point yet, but they're suggesting that that will happen in 2024 at some point. We have seen some legislation that is due to come in. Again, we imagine that will be at the same time in 2024. That is making things a bit easier for employees, we think, in the sense that from 2024 at a time to be decided, and we'll let you know when that is, they can put in 2 flexible working requests a year, and the amount of time that employers have to respond to the flexible working request is going down from 3 months to 2 months. There are a couple of other changes as well, and probably it will be interesting to see in particular how the one about employers needing to consult with their employees about the request, it'll be interesting to see how that one plays out. So that's just worth remembering. But for the moment, if an employer wants to get their employee back to the office, they can put in a flexible working request. And this has to be dealt with fairly, and I'm sure a lot of the people listening have got processes and procedures and policies in place to help them deal with those. And I just thought it was worth mentioning and reminding everyone that successful tribunal claims can be brought about employers failing to properly deal with flexible working requests. I think it's fair to say that they are quite rare. It's not something we see often, and I think either John or Keith will touch on a reason for that a bit later. And actually, there might be a more obvious claim that employees could bring if they are unhappy with the outcome of a flexible working request. But if a successful claim is brought on this specific point, employers must make a declaration to that effect, and they may also make an order for an employer to reconsider the request and also award the employee some compensation. And it's as much as the tribunal considers is just and equitable in the circumstances, but there is a maximum permitted figure, which is 8 weeks capped pay, and that is the statutory cap that's applicable at the time. So that's kind of the most obvious claim that came to mind when we were thinking about all of this. What are the claims?
Yeah, it's a funny quirk of the law, really, that the key way that an employee can challenge a requirement to have to work in the office all the time is the flexible working request. But in a way, that claim, if the employer gets it wrong, that claim is probably the least of the employer's worries.
Yeah, I agree.
If they run into trouble with an employee in relation to these sorts of claims. I've had a few clients now come to me and say, look, we want to get our employees back in the office more. And the first thing that they've always said to me is, but we're worried that it may be a breach of contract because our employees, when we've started talking to them about it, have said, well, custom and practice says that because I've been working out of the office at home for the last 3 years, that is now my contractual right to work out of the office. I think I'm not really convinced particularly by that argument, and there must be a risk of that, and it will very much depend on what's been said when. But in my experience, in almost all circumstances, um, custom and practice changing someone's terms and conditions of employment is a lot harder to establish than people think it is.
It's interesting, isn't it?
Yeah.
Because it seems to be a real concern. What were you going to say,
And I
John?
was going to say, it crops up
Yeah.
all the time, I
Yeah.
think, and not just in relation to, this topic, but people will very often raise, oh, could it be custom and practice? Whether it's, the type of payments that are being made, for example, in a redundancy situation, could
Yeah.
that be custom and practice if you're enhancing redundancy payments a certain way, or if you're making certain payments under a bonus scheme, could that become custom and practice? And often it's something that is raised an awful lot, but I think it's worth just kind of thinking over what the legal test is for something like that to actually
Yeah, and
work.
it's a pretty tough test, because the first point worth bearing in mind is that you can't imply a term that is directly contradictory to an express term in the contract. So if you've got a term in the contract that says your normal place of work is so and so office, then it is really, really difficult in legal terms to imply into the contract a term that says that your place of work is somewhere else. So that's your starting point. And then if there is a chance to imply a term, there's the three-limb test for a term to be implied. The term being implied has to be, to use the legalese, reasonable, notorious, and certain. Reasonable is fairly straightforward. So if it's a reasonable term, then it can be implied. And normally you would say it could well be reasonable that if someone's worked at home for the last 3 years and they're saying, well, I think there's a term now that's where I work, that's my normal place of work, that could well be reasonable. It's probably not that issue that is the tricky one. Notorious, that's the legal term for everyone knows about it. So if people don't know about it, then it's not notorious. And that's, again, you may be able to say that everyone knows about it. The other term is certainty, and that's where a lot of claims about custom and practice fall down, because if it's not certain exactly what the position is, then it won't be strong enough to get in as an implied term. So, for example, if people are working different hours in the office, so you've got some people in some teams working a bit more than others, you've got some people that never come in at all, you've got some people that come in all the time, or it varies from time to time. It's really tough in those circumstances for someone to say it's absolutely certain what my legal position is in terms of working from home, because if what they do is a bit different to someone else and what they do isn't consistent, how can you possibly say, well, it's absolutely certain that I'm allowed to work from home? Oh, but sometimes it's 3 days a week, sometimes it's 2 days a week, sometimes it's never, sometimes I have to come in all the time.
And it's when you put that together with the other limb about notorious,
Yeah.
so everybody knows about it and it's certain. So if you've got this kind of really different set of practices, then what is it that everybody knows?
Yeah.
Which one of those practices does everybody know about?
Yeah, and it's not enough that, well, it's certain that sometimes I'm allowed to work from home. That is never going to fly as being something that you can say is certain enough. It's important to get our heads around this, though, because the consequences, if you could say that this is an implied term, are really important, because then if you're talking about potentially changing that term for, certainly if you're talking about changing that term for 20 or more people, you are potentially getting into the realms of collective consultation about that. And that might mean sending a notification to the Secretary of State about the fact that you're going to impose a change in terms and conditions. We're going to talk a bit later in this podcast about what the consequences you are prepared to impose on people are if you're an employer that wants to get people back to work. How far you're going to go. And if you're talking about, well, I'm prepared to dismiss people if they're not going to come into the office, then you're clearly in collective consultation territory. And that brings with it all sorts of things like set timetables, finding the right people, whether that's a union or elected reps, to consult with. So it is a big deal. I think my default position is it's going to be pretty unlikely, subject to exactly the situation that you've got, but by and large, pretty unlikely that we're going to be talking about an implied term, and that you're going to have to formally be talking about changing people's terms and conditions. But you've just got to be alive to the fact that if that's where we are, then it's a really big deal, and you need to plan how you're going to approach that really carefully.
And I think it comes back a little bit to what we were talking about in the previous episode about understanding what you currently have within your business. And as you say, I think I'd be absolutely where you are, that the starting point in most cases is that you wouldn't want to in any way concede that there was any sort of implied term. But if you've introduced specific types of policies, because obviously when we were coming out of the pandemic, as you said, Micheala, at the start of the last episode, we were seeing a lot of people introducing new policies, and actually it was seen as a really positive thing in terms of attracting new talent, being really open about how flexible you were as a business, etc. So if you've introduced a policy which you may have expressed as being discretionary, but it still sent a very clear message that you do allow people to work in a sort of hybrid fashion. And depending how far you've gone with that, because some organisations may potentially have changed, contracts as well. So if you've done all of that, you could be in a very different position in terms of the likelihood of needing to do something like collective consultation.
Yeah, definitely. And in these 2 episodes, we've identified a trend, kind of initially, people, as you say, getting these hybrid working policies in place, and then a further trend more recently. We've seen it in the news about employers wanting to get more employees back to the office. I don't think we've said it explicitly, but there is no doubt that hybrid working is still really important to employees. I've seen a lot of stats that employees do really value it. So there's definitely that tension there. The next claim that I think we wanted to talk about, or potential claim, is kind of more linked to the flexible working request. And yes, as Keith alluded to, whilst it's important to deal with flexible working requests fairly and all of that kind of stuff, as I said, it's not a very common claim. And I think the more common claim we see linked to all of this kind of stuff is discrimination allegations.
Yeah, and I think historically, whenever a client has come to me to ask about, a flexible working request and, what are the risks involved, as you say, my immediate focus is not on the flexible working request itself, because largely that has been something that if you go through the right procedure, you're okay in relation to that claim. The question is there any underlying potential discrimination claim? And usually the two, which I think you mentioned earlier on, usually the two that you would expect to see might be something like discrimination on the grounds of sex or discrimination on the grounds of disability. So I think you can quite readily see that you may well, for example, have female employees arguing that if they are required to come into the office for more days a week or permanently into the office when they've been allowed to work from home, arguing that because childcare responsibilities tend to fall more on women than they do on men, that inherently indirectly discriminatory. So that's one possibility.
And it's worth saying that tribunals, and there may be a time when it's different to this, but tribunals are very ready to accept still that the principal burden of childcare does fall on female employees. So they're really pushing an open door if they're running that argument, because it remains the way of the world, for right or wrong, but it is the way of the world, and the tribunals accept that.
And I think the other area is in relation to disability, and obviously this will very much depend on the particular individual and the circumstances that you're dealing with, because there's all kinds of different, obviously, medical conditions that may affect people in very different ways. But you can quite easily see somebody with a particular disability potentially being able to argue that it's discriminatory to insist that they go into the office because they are going to be disproportionately affected by that because of their medical condition. And you then get into all the areas of reasonable adjustments. Is it a reasonable adjustment to allow that person to work from home permanently or more often than a particular counterpart who does the same role? And we've had things like commentators talking about, for example, employees who are neurodiverse may find it more beneficial to be working from home. Employees with ADHD may find it overwhelming to suddenly go from being able to work from home really regularly to an open plan office. So all of those things could be raised. And we're back to this point about having to look at each case very differently. And if you imagine now we have this situation where we're expecting flexible working to be a day one right, that's literally all of your employees could potentially raise a flexible working request. They can potentially, when the changes come in, do it twice a year. You suddenly have a huge administrative burden in terms of dealing with all of that, because you're going to have to look at all of them. You're not going to be able to have a blanket policy for everything. So I think those are probably the most tricky claims that you may face if you're looking at changing your policy in terms of hybrid working.
Yeah, I agree. And particularly, just picking up on your last point, with larger workforces, the administrative burden and kind of logistically how to deal with all of the flexible working requests that might come in at a similar time gets even worse, doesn't it? Because you're trying to look at the impact of granting certain flexible working requests for some employees, maybe, and compared to others, and what you do about that. So what are the options then? An employer is deciding to go ahead with something like this, but their employees are not complying, either on quite a small scale or on a fairly large mass scale.
Yeah, I think that the key thing, if you are an employer, and given the title of the podcast, if you are making your business to kill hybrid working in your workplace, or at least severely wound it because you want people more back at work, I think you've got to have a plan at the outset, because you can't assume that just because you say to everyone, right, we want you all back in the office, that people are simply going to obey without question. So you've got to think through the logical consequences of what you're asking people to do. For example, how firmly are you going to push it? Are you not going to take no for an answer if it comes to people, for perhaps really good reasons in their own view as to why they can't or won't come back to full-time or more office working? Are you prepared to say to them, well, in that case, you're going to have to resign? Or if they won't resign, are you going to be prepared to say to them, well, we're instructing you to come in 5 days a week, for example. If you don't, we're going to view that as a disciplinary issue and we're going to take you through the disciplinary process. You've absolutely got to, in my mind, I think, if you're going to go down that path, have a really firm idea of where you're prepared to end up, because going into this thinking, well, people will just accept it and we'll get everyone back because we've asked, I think that may be unrealistic.
And thinking about that, I suppose there's a couple of things, and we touched on this in the last episode. I think the idea of, I would suspect that a manager's answer to the question of how far would they be prepared to go would be very different if they're talking about a poor performer as compared to their star performer or one of the most important people in their team. And also, to take your point about how many people might apply at once for things like flexible working, if you've got one person who's digging their heels in, you might be prepared to push things there. If you've got half your workforce saying we're not going to come back, what are you going to do then? So trying to understand, just what the consequences could be and how significant the impact could be if it's some of your best people or lots of people, as compared to just the odd one here or there, I think is going to be really important.
And I think as well, it is, as with many things, it depends on the employer's attitude to risk, because actually I know I act for some clients that are very happy to respond to employment tribunal claims and defend them and take things all the way to tribunal. Others are less happy to do that. But ultimately that could be the worst case scenario. You get a kind of massive employment tribunal claims that you're trying to deal with and think about what sort of precedent that sets. I think that's a good point to leave it on, really. Kind of the recommendation from us to, if an employer is thinking about doing this kind of thing, go into it with a real game plan and know before any adverse consequences happen. Obviously, of course, we hope these things go smoothly, but I think employers should be prepared for some pushback from employees. And if that happens, employers should know how far they in turn want to push back. Thank you.